Supplementary list, item 1.
Lordship, this matter is still pending before the Supreme Court, Lordship. There's
Sorry?
I'm sorry, Lordship.
Principal Commissioner, Income Tax Construction. None appears.
My lord, I am appealing for the appellant, my lord, the Principal Commissioner of Income Tax, lordship. My lord, in this case, I have instruction to withdraw the appeal, my lord, as my lord, it is below the threshold limit as prescribed by the latest notification.
All right. Learned counsel.
I'm appearing on behalf of respondent, my lords.
Learned counsel for the appellant submits an instruction that his client proposes not to proceed with this appeal as it is below the ceiling. As the tax effect involved is below the ceiling. Paragraph. Accordingly, the appeal is dismissed as withdrawn.
Gratefully, your lordship.
I am applied.
From the daily list, item number 1.
Lordship, this matter is still pending before the Supreme Court, Lordship. There's some interim order passed by this court. Now the state has filed an SLP before the Supreme Court. Now that is still pending.
You're for the petitioner.
For the petitioner, Lordship.
Learned counsel for the petitioner seeks further adjournment of the application on the ground that the matter referred to in the order of this bench dated 20 August 2024 is still pending. Paragraph lists this application on 10th December.
Lordship, it may take some time, Lordship. It can be listed after 6 weeks.
Let it be listed on 10th December, you tell us.
We'll mention. Obliged.
Item number 2.
May it please your lordship. Lordship, in this matter, we've already taken steps, your lordship, but we are still awaiting service report, your lordship.
Please speak a little louder.
Lordship, in this matter, we've already taken steps, your lordship, but then we're still awaiting for the service status, your lordship.
This application is adjourned till 28 November to receive the service report.
Much obliged, lordship.
Item number 3.
My Lord, I am appearing for the state, respondent number 1. My Lord.
None appears for the appellant. Learned counsel represents the respondent number 2.
My Lord, I am for the state,
Respondent number 1.
respondent number 1.
Yes. We have perused the office report. Which says that the letter by registered post issued to the respondent number 2, registered post with ID card, to respondent number 2 has been returned by the postal authority with the remark that, quotation, no such person on this address, unquote. This appeal is adjourned till 2/8 November 2024. Full stop. Advocate on record for the appellant is directed to verify whether there has been any change of address of the respondent number 2 and to report to the court accordingly. Comma for proper service of notice.
Item number 4.
Okay.
May it please your lordships. Your lordships, this is an appeal, your lordship, aggrieved by your order by the single bench, your lordship. Your lordships, here I was appointed in the year 1991 as a casual worker, your lordship, in the office of the respondents. Thereafter, your lordship, in the year 2003-2006, my name was reflected twice in the list which they have proposed for regularization. Then, your lordship, I was verbally assured that my post would be regularized. Now, in the year 2019, one of the cleaners, your lordship, she was retired. As such, your lordship, I had made a representation to consider me in her post. However, your lordship, That was denied on the ground that I do not fall under the word charge establishment. Your Lordship, thereafter, during the course of hearing before the single judge, Your Lordship, they changed the stance and stated that I am a part-time worker, Your Lordship. Now, Your Lordship, I have been in service for more than 30 years now, Your Lordship. And I
What
have
kind of work you are doing?
a cleaner, Your Lordship. I'm a cleaner. Now, Your Lordship, for more than 30 years, Your Lordship, now they're taking the stance that I'm just a part-time cleaner. But Your Lordship, if you peruse, Your Lordship, the materials here, Your Lordship, you'll see that my timing, my hours of working, Your Lordship, it's not just from 8 to 10 as they have stated.
But they have regularized other contractual labor.
Similarly placed those who were there in the list, Your Lordship, in the year 2003, 2006, with my name as well, whose names have been reflected, they have been regularized. And recently also another person have been regularized.
Show us the judgment of the learned single judge.
Your Lordship, that is page 106. A relevant portion is page 109, Your Lordship. Your Lordship, what happened there, Your Lordship? The learned single judge has only asked them to consider for my regular casual worker status, Your Lordship. Now, even that also, Your Lordship, they have stated that I will only be entitled to regular casual worker in the year 2023.
Where is the appointment letter?
Let's check, Your Lordship. Your Lordship, we just have the 1993 appointment.
Page 31. 30 and 31.
Your Lordship, we do not have the initial appointment of 1991, Your Lordships. But if Your Lordship see page 35 and 40, Your Lordship, you'll see that I was appointed since the year 1991.
Was the word part-time there?
Your Lordship, according to this page 99, Your Lordship, if I take Your Lordships to page 99.
Not the writ petition which was enclosed, which was filed before the Honorable Assembly Judge. Now, there, my lord, in page 31, the Rani page 31, 30 is the office order, my lord, 31 is the typed copy. So, my lord, kindly takes a look at page 31.
So this is a 1999 document.
1999.
In 90, there you have declared her as part-time worker. But that is the bone of contention. Whether the appointment was part-time or not.
Your Lordships, if I take Your Lordships to page 99, Your Lordships.
Yes.
Your Lordship, there you can clearly see Your Lordship is on casual basis, my appointment.
Nothing is there part-time. Later you have converted him into a part-time worker.
My lord, the stand which we have taken in our affidavit, my lord, even in the earlier round, my lord, is that the appointment of the
You have taken, but the learned judge has held that whether part-time or full-time is not substantiated. And the appointment letter does not say part-time. If it does not say part-time, it has to be presumed to be full-time.
My lord will kindly appreciate, my lord, the duty hour was between 8 to 10, my lord.
Maybe
Your Lordship,
8
that...
to 2.
Yes,
That is
Your Lordship.
incorrect. We have stated in our affidavit it is 8 to 10, my lord. It was, her duty hour was prior to the, my lord.
Now, if you give somebody less duty hours, that doesn't make somebody into a part-time worker. That is your problem. Why did you give 2 hours duty? You should have given 8 hours. But in the appointment letter, you are Mr. Bhattacharya.
My lord.
Yes. You have not said anything. So don't deprive this person.
My lord, even if it is assumed, my lord, that she's a casual employee, my lord, even if it is assumed, my lord will kindly appreciate, we have filed an additional affidavit before this honorable court dated 19/6/2024.
Yes. Which page is the affidavit?
My lord, the relevant, if I am allowed to take, my lord, to annexure 4, my lord. Annexure 4, page 11. My lord, the gradation list, it starts at page 12, my lord. Now, in the gradation list, my lord will kindly see. My lord, the petitioner is placed at the bottom, my lord, 98. So, my lord, my lord, there are several other people who are senior, my lord, in terms of seniority, and the posts have not been considered. My lord, even if it is assumed, my lord, for argument's sake, that it is within the zone of consideration, my lord will kindly see the petitioner falls at the bottom, my lord, 98.
Your Lordship, I disagree with that, Your Lordship.
My lord, there is another aspect, my lord, as far as the age is concerned. My lord, in one of the documents, it is showing 1960, my lord. Subsequently, petitioner has tried to bring another date of birth on record, that is 1968, my lord. Now, my lord will kindly appreciate, but there cannot be a difference of 8 years, my lord. if even assuming there is some anomaly in the date of birth, my lord, 8 years is a huge gap, my lord. And if 1960
What is this date of conferment as RCW?
RCW is a scheme, my lord, regular casual worker scheme. So, my lord, what happened is that pursuant to the direction of this honorable court, that you kindly consider the RCW status of the petitioner. So, my lord, while the matter was pending consideration before the government, so in the meantime, my lord, prior to the prematurely, this rate appeal was filed, my lord. Now, during the pendency of the rate appeal, my lord, that conferment of RCW status was given, my lord, to the petitioner, as per the direction of the learned single judgment. As a special consideration, my lord, that was granted to the petitioner. Now, my lord, if 1960 is taken, my lord, the petitioner ought to have retired prior to approaching this honorable court, my lord.
So you have already got RCW status.
Your Lordships, that's the thing, Your Lordships. See, the RCW conferment, Your Lordship, it's after working for 10 years continuously as a casual worker. Now that RCW status is conferred. Now, Your Lordship, they are conferring me as 2023, the RCW status, as on 2023. Now, I've been working since 1991, Your Lordship. After 10 years, I ought to have been conferred RCW status. Because the RCW status, Your Lordship, it does give us some benefits, Your Lordship.
What benefit? Pension?
Your Lordship, page 48, Your Lordship, is the RCW notification.
No, what is the date of the, show us the scheme?
Yes, Your Lordship, page 48.
Who is the authority to consider?
But the authority is the Personnel and Administrative Reforms Department. But my lord will kindly appreciate, my lord, if I draw my lord's attention to page 84, my lord, of the writ appeal. My lord, during the course of the proceedings before the learned single judge, my lord, a clarification was sought from the Honorable Court with regard to the status of the service of the petitioner, my lord. Now, there, my lord, we have stated very categorically, my lord, if I am allowed to read, my lord.
This is in 2022, you are saying part-time. You have to go by the initial appointment.
And my lord will, another aspect, my lord will kindly appreciate, my lord, there was an RTI which was filed by the petitioner, the appellant herein, my lord. Now, what is the response to the RTI, my lord? That is at page 100. And 101, my lord, these are the queries. To RTI application dated 8/12/2022, sought by advocate so and so. So, my lord, these were the queries. How many casual workers are appointed during the year 1991 to 1995? Then, my lord, names of the casual workers. So, pursuant to that, my lord, in response, my lord, at page 102, my lord, the list of names have been given out, my lord. So, my lord will kindly see, my lord, the petitioner's name does not feature anywhere. This is year of appointments, my lord. Plus, her salary was given from a different account head, my lord. It is not under. But these are the names, my lord, will kindly see. 1 to 17.
But this is not the ground you had taken before the learned single judge. Only one ground. Only one ground taken that she was part-time. That's all. These things were not taken. Now you are taking this from the bar.
No, my lord, if I am allowed to refer to our affidavit, my lord, which was filed for the learned single judge. Even this clarification was, my lord, filed by way of an affidavit before the honorable single judge, my lord. My lord, our affidavit starts at page 51, my lord. So, my lord, if I'm allowed to draw my lord's attention to page 52, paragraph 5, my lord.
Yes.
Should I read, my lord?
Yes.
That with regard to the
Yes.
That with regard to the averments made at para 2 and 3 of the writ petition, the answering deponent states that as per office records, the petitioner was engaged as part-time cleaner and drew her first salary in the month of April 1993. It is pertinent to mention herein that in view of the fact that Srimati A. Kharmujai was on leave, the petitioner was allowed to officiate against the leave vacancy of the above incumbent on a number of occasions, and such officiating appointment was purely temporary. Then, my lord, para 7, which is at page 53, my lord. That with regard to the averments made at para 5 of the writ petition, the answering deponent states that due to an inadvertent oversight, the letter dated 8/12/2023 was issued, whereby the petitioner who was engaged as a part-time cleaner was erroneously entered. However, necessary clarification against the same has been submitted to the office of the CE, wide letter number so-and-so dated 17/9/2014, whereby it was clarified that the petitioner was appointed
The
as
salary she received was for full-time or for part-time?
part-time, my lord. My lord, here it is categorically stated, my lord, where she is drawing her salary from. Drawing salary from 2059 wages, plan, non-plan. And since her name was omitted from the list of regularizations, she is not a work charge staff. So that also we have denied, my lord, in our affidavit.
Your Lordships, I've been receiving monthly salary, Your Lordships. Initially, it was 1,000. Then later, it was enhanced to 5,000. And after filing of the writ petition, I was brought under the minimum wages.
My lord will kindly see this. All these paragraphs.
This 1,000 per month is in the letter, that you will get 1,000 per month.
They've also stated that in the affidavit of theirs also, Your Lordships.
Per month.
Yes. Then it was
Initially.
subsequently enhanced to
That
5,000.
with regard. My lord, again, para 8, everywhere we have stated that only, my lord. That with regard to the averments made at para 6 of the writ petition, the answering deponent states that wide letter dated 14/10/2004, the petitioner was allowed to officiate as cleaner against leave vacancies for a period of 14/10/2004 to 13/11/2004 on purely temporary basis until the return of the incumbent from leave.
Mr. Bhattacharya, when you are regularizing casual workers, why become so unnecessarily harsh on one?
No, Lord.
But
My lord, we
this
kindly
is
appreciate-
also doubtful. It is not clear at all.
No, my lord will kindly
Yes.
kindly
So it is
appreciate.
better that the benefit of doubt is given to her and not to you.
But my lord will kindly appreciate, my lord, that additional affidavit that we have filed before this honorable court. My lord will kindly see the list of incumbents, my lord, whose
Yes.
regularization.
But then it is 10 years. There you have some discretion. May. So whether it is from she joined in 93,
91, Your Lordships.
completed in 2001, 10 years,
2001, 10 years. I should have ought to have been conferred RCW status in 2001.
you had a right. Not that they were bound to. They may. So that you consider, whether from 2001 or 2003, but certainly not 2023. And you have regularized so many persons.
No, my lord will kindly, my lord, my lord, if I'm allowed to draw my lord's attention again, my lord. My lord, at additional affidavit, page 12. My lord will kindly see the number of people who are still awaiting, my lord, regularization. They have not been. My lord, it is subject to vacancy and a lot of other factors. My lord will kindly appreciate, my lord, if I can draw my lord's attention to page 12.
All
my
that
lord.
discretion is yours, subject to the number of posts under that scheme, right?
My lord.
That regulars, casual workers upgraded to RCW this,
Yes.
and to the extent of the number of vacancies. All right. That is all right, but that is also seniority wise.
Seniority wise, my lord.
So you include her in that list, and seniority wise you deal with it.
That is
Your
what we are
only
saying.
point is she was not a casual worker, a part-time casual worker. There is nowhere in the records. The appointment letter is casual worker.
No, my lord, there are several appointment orders, my lord, where it is orders, my lord, where it is categorically stated, my lord, that she is a part-time, my lord. If
That is post-appointment.
post.
Yes, it's like post-appointment, if I am converted into a part-time judge, I will become a part-time judge.
So my lord will kindly appreciate the delay also, my lord. The petitioners approached this honorable court after a delay of considerable delay of, my lord, 2019 she is
The
approaching.
amount the government is spending on litigation, if 1/10 of the amount went to this worker, the worker would have been much better.
Your Lordship, with regards to that also, Your Lordship, I'd like to clarify.
Who's appointed in the government? No mention of. Later they have.
My lord, will-
part-time.
My lord, another interesting aspect, my lord, if I. My lord, another very interesting aspect, my lord, if I'm allowed to bring to the notice of this honorable court. My lord, if her date of birth is 1960, my lord.
That is not taken before the learned single judge. You can't invent grounds here.
My lord, this is a part. This is a part of record, my lord. It's already a part of record. I'm relying on the record which is, my lord, which is there in the writ petition itself, my lord.
No. Where is that thing done?
My lord, that is at page 35, my lord.
Compliance with Justice Thankful's order.
My lord, page 35 is the annexure which is enclosed by the writ petition, my lord. Here her date of birth is shown as 3/6/1960, my lord. And 1968, my lord, there is a huge gap of 8 years, my lord. Is that possible?
No. Where is the appellant in this list? 106 serial.
My lord, in the list, my lord, is 98, my lord, serial number.
'98.
In the serial number, my lord,
It's in the
list
additional affidavit.
in the additional affidavit, my lord,
Page
which is at
14.
page 12. So, my lord will kindly see serial number 1, Bolram Sarki. My lord is found it. My lord, kindly see their date of joining, my lord, 1/8/1989. Even ahead of the petitioner, even earlier than the petitioner, my lord.
Date of birth is 3/6/1968.
My lord. Now this, what had happened, my lord, I have verified. Later on, my lord, she submitted some birth certificate, my lord, purported birth.
As per your records.
My lord.
Then?
My lord will kindly see the discrepancy, my lord, 1960 and 1960.
Where do you get 60?
1960 is that earlier record, my lord, that is at page 35. 35 of the writ appeal, my lord. Because this was done due to some certificate being produced by her, my lord, at a later stage.
Then?
That is sometime in the year 1993. No, my apologies, my lord. This was taken out in 2017, my lord, this certificate. Page 35, my lord. Now at the bottom of the list, my lord, serial number 16. Dil Kumari Chetri. Part-time cleaner, 3/6/1960, my lord.
This point you have taken in your affidavit. Date of birth.
Yes, my lord.
In the affidavit filed before this division bench, lordship.
They have
In the
taken.
appeal. Here, not before the single judge.
My lord will kindly appreciate it's a part of the record, my lord. Subsequently, my lord, we had to do some research. My lord, we approached this is what is included in our additional affidavit. My lord, we approached the school. My lord, and then we have found, my lord, this is at page 15. We have found out the birth certificate.
No, was it there in before the trial court or not? The only point is part-time, full-time, that's all.
My lord.
And there's a latest judgment of the Supreme Court
My lord.
that if there are 2 dates of birth have entered the records and you wish to correct by incorporating a date which advances the year of retirement, then you have to give a hearing and pass a reasoned order. You can't do it on your own.
So, my lord,
Chief Justice and Justice Bose's order to 2022 or something SCC.
so my lord, of course, that much concession the department has given, my lord. Not only that, another concession, my lord, the RCW status has also been conferred on her, my lord. So, my lord will kindly see, and the length, my lord, she is getting additional 8 years of service already, my lord. That much benefit
That we
is
don't
already
know.
granted.
Additional 8 or not, that we don't know. As per your records, it is 68.
So both are there, my lord, 60 and 68. And 68, my lord, because it is the petitioner who subsequently produced, my lord, if I am allowed to take, my lord, to the additional affidavit, my lord. This is at page 15, my lord. My lord, this was the certificate which was issued in the year 2017, my lord.
All right.
This clarification is on the next page, my lord. That is page 16. Sorry, my lord, apologies. It is at page 17, my lord.
All right. Yes, please take down.
My lord, if I'm one citation I was having, my lord, if my lord, this is my lord, this is SCC, my lord, 2007, 15 SCC 680. My lord. Lord, if I'm allowed to draw my lord's attention to paragraph 5, my lord, of the said judgment.
How does it help you, Mr. Bhattacharya? This is a case where the High Court said that you appoint a full-time sweeper that can fill up the vacancy. They said that no such vacancy is there. How did it?
But
This is not right. Yes, please take them.
I also wanted to rely on Uma Devi, my lord.
All right.
My lord, I have a copy of the judgments, my lord. Uma Devi.
You know the effect of citing this judgment? Have you appreciated the effect? We will strike down your whole list of regularization and say that you start a regular recruitment process. This kind of absorption we will strike out following this. Shall we do it? Why are you citing this? You are yourself recognizing them as having done a job of a permanent nature
Now as a
for a
RCW.
continuous time,
RCW.
and you have regularized a few dozens. So she's saying that regularize me also. That is the case. Uma Devi says regular appointment and no absorption of casual workers. Then we will strike down the whole list.
These are actually master role workers.
Then, please take down. The appellant has been rendering has since 1993 been rendering the menial service of a cleaner in the office of the executive engineer PWD bracket RDS NH Shillong Bypass Division Shillong Bypass Division. Her appointment letter of 19 July 1993 was to this effect. Page 99, marked portion. On paragraph on 16 September 1996. The personnel and ADMB stop reforms bracket B, Department of the Government of Meghalaya, published a memorandum entitled Casual Master Role Workers, Wages and Benefits. By this memorandum, the Meghalaya Regular Casual Workers Scheme 1996 was introduced. It applied to casual workers employed in the departments and offices of the government. And who had been working for a continuous period of not less than 10 years. Full stop. Full stop. On fulfillment of this eligibility criteria, a casual worker would be granted the status of a regular casual worker within quotation bracket RCW. The benefit of being included in the muster roll of RCW under this scheme was that in case of any vacancy in Group D post, it would be filled up from amongst the workers in that role. In the case made out by the respondent, paragraph, in the case made out by the respondents in the affidavit in opposition, it appears that the solitary reason, the solitary ground on which the appellant was denied consideration to be included in the list of beneficiaries of the scheme was that, according to the department, she was a part-time worker. Full stop. Only full-time workers were entitled to the benefit of the scheme. Full stop. Being part-time, she was ineligible. The learned single judge on 20 June 2023 disposed of the writ petition by identifying the dispute with regard to the nature of appointment, but nevertheless observing that considering the length of service, the length and continuity of service, the respondent should consider the case of the appellant. Mr. Bhattacharya, learned counsel appearing for the respondents, points out from his affidavit in opposition from the additional affidavit in opposition that subsequently the appellant has been included in the list of RCWs as on 1st May 2024. As the last person in the list. Hence, according to Mr. Bhattacharya, the order of the court has been complied with. Full stop. He further adds that the date of birth of the appellant indicated in the list is erroneous, and that his year of birth is 1960, that her year of birth is 1960. Full stop. Such was recorded at the time of her initial appointment. Full stop. Later on, it is not known how it was changed to 1968. We do not know how the department gets, on what basis the department confers RCW on the appellant with effect from 19th September 2023. In the letter of appointment of 1993, she was appointed as a casual worker at a salary of ₹1,000 per month. full stop. There was no mention that the appointment was of a part-time casual worker, full stop. There was also no mention of any duration of daily work, full stop. Now, the respondents contend that the petitioner, the appellant, was working for only 2 hours a day from 8 a.m. to 10 a.m. We reject this contention, full stop. We have to go by the letter of appointment, which plainly mentions that she was appointed as a casual laborer, from which it is to be presumed that such appointment was not part-time, full stop. Secondly, when no duration of working hours was mentioned, it is to be presumed that she was required to work full-time. Paragraph. According to the scheme, on rendering 10 years continuous service, the appellant became eligible to be considered for appointment as RCW. Therefore, in our considered opinion, she became so eligible in 2003. As regards the age issue raised by Mr. Bhattacharya, we observe that it was not the bone of contention before the learned single judge. At this point of time, the department has to go by the age mentioned in the list of RCWs as in May 2024, annexed to the additional affidavit. Full stop. One point raised by learned counsel, one point raised by Mr. Bhattacharya has substantial merit, the point being that a list of RCWs may be maintained, but absorption and regularization can only be made on the basis of vacancies occurring and such vacancies being filled up from the list in accordance with the scheme. Paragraph. In those circumstances, we dispose of this appeal by directing the respondents to revise the list of RCW on the basis that the appellant was appointed as a regular casual worker, a full-time Now, the appellant was appointed as a casual worker without any nomenclature of part-time. V-Day appointment letter dated at 1993 data. Furthermore, on expiry of 10 years, that is in 2003, she became entitled to be considered to be included as RCW. Such a revised list now the entry of the appellant against item number serial 98 of the said list is set aside. Let a fresh list of RCW be published within 1 month of communication of this order. The impugned judgment and order of the learned single judge dated such and such is modified to the above extent.
My,
Yes?
my lord, my humble apologies, my lord,
What?
for interjecting. Only one small clarification, my lord. My lord, the first judgment that we've relied on, my lord, we wanted to impress upon this honorable court that the post which is petitioner is wanting regularization, my lord, it is not a permanent post, my lord. That was why I had, my lord, referred to this.
Where is that contention before the learned single judge?
We have stated, my learned single judge, only thing I've stated is that she is a part-time employee.
That is all right, but whether permanent post or not is not material. It is only that list is material. If the post is not there, not there.
My lord, another aspect.
The absorption is from that list.
My lord, another aspect, my lord, my humble apologies. My lord, there is also a substantial delay, my lord, that we have taken. My lord, the delay she is approaching in the year 2019, my lord. Whereas her appointment is, my lord, if it is taken 1993.
But that again was also not taken before the learned single judge.
My lord,
But your lordships, for that also I've clarified, your
no
lordship.
delay we
because
have taken, stated, my lord.
in the year 2019, one cleaner was retired. On the basis of that, your lordship, I had made a representation. Before that, because I was verbally assured,
That delay we had taken that ground, my lord, in the affidavit.
When was the representation made?
before filing of the petition. (18 to 2019).
Representation.
Yes, your lordship. Because that cleaner, A. Kharmujai, she also retired in that year. So on the basis
From
of
the
that,
permanent post.
yes.
Huh?
So taking that into consideration and the Group D post, your lordship,
You
therefore,
also had somewhere, Mr. Bhattacharya also contended that there was substantial delay in preferring the writ, and that on that ground the writ ought to have been dismissed. Learned counsel for the petitioner meets this point by submitting that only on the occurrence of a vacancy after retirement of a cleaner holding a permanent post that a representation dated
18/2/2019.
18th February 2019 was made by the appellant. Hence, the cause of action of the appellant arose at that point of time.
Item number 5.
Who's in item number 5?
Obliged, my lord.
Obliged, Lordship.
Mr. Bhattacharya, you are not praying for stay of operation of this order? If you want to pray, you pray.
My lords,
If you want to pray for stay of operation of this judgment, you pray.
my lord.
Poor worker, leave her alone. Yes.
My lord, this matter I'm praying for some accommodation. My lord, my throat is not well, my lord, today. My lord.
Only for the day?
It may come next week or after 2 weeks, my lord.
Why 2 weeks?
No.
Don't
My lord-
aggravate your throat problem like this, that it will take
This
2 weeks to.
my lord, spouse is suffering from kidney failure, requiring execution of hemodialysis thrice in a week. And I have submitted bill for 11.5 lakhs, 54,000. The money has been set aside, my lord, pursuant to lordship's order,
Oh.
so, 15 lakh rupees.
Bill is pending, my lord, with them. Last order was, my lord, 16,
Just for one day, my lord.
16/10/24. Last order was passed, your lordship.
30th October.
No, 16/10.
16th October.
They have kept deposited in a separate account, 15 lakh against this proceeding on 20/10/2024. My outstanding bills are still pending. It is,
All right, we will keep it on the 21st. 21st, 1 week hence.
Right.
On the,
then 22nd, my lord, 21st, I'm little.
on the personal ground of the learned Deputy Solicitor General. We adjourn this matter till 22nd.
Much obliged, much obliged.
I'm deeply